Yep. Sir, thank you, sir. Yeah, different courtrooms here.
Usually where the juror is, right? Yeah. It seems like ever since I've only been out here a handful of times since you guys moved from the other building, and it just so happens that every time I come out here, it's check mark. I do too.
Good.
She was great when she was a magistrate. She's been great for a long time. I mean, this community is lucky to have her out here.
Hard will help us out when you get questions. She'll give you the real answer, not that like, yeah, like so she'll just give you, hey, here's what it is, and I appreciate things. It makes life easier.
Good, bad, and different.
That makes this job.
Now I hear, is it Oakley that's retiring? Green's retiring.
Yeah.
I thought Oakley was retired. It's Tina Brooks Green's retiring.
Wow. Yeah. She'll be done here.
She's been on the bench
forever. Yeah, my entire career and probably some more. Yes.
Yeah. Who's presiding out here now? Is it Oakley now or
Oakley is, and then I don't know who's running. I don't know who's trying to get her.
Yeah, I don't know who's running. I've seen some signs, but I don't come out here enough.
No, I don't. I've seen signs too. I just don't know who they are. Like, this person, she is. I don't know who they are.
Is Hinman gonna run?
I don't think so. I think he's done with. He's barely here anyway. He's been a magistrate for probably a year or two. It seems like he's been. I think his career is coming to an end too. I think he's riding the sunset.
Yeah, makes sense. All right. Third, fourth, fifth, court's now in session. The Honorable Lisa Martin.
You may be seated.
Morning, Judge. Afternoon, Judge.
Good afternoon. I'm sorry. I'm not
still-
accustomed to seeing Mr. King here. It caught me off guard.
Surprise.
Surprise, surprise, surprise. This is 240392 FY, State of Michigan versus Charles Campbell. May I have your appearances, please?
Good morning again, Your Honor. APA Larry King for the people, P 78774.
Good morning, Judge, to you and your staff. Cody Bradford, Neighborhood Defender Service, P 85944, here on behalf of Mr. Campbell, who stands to my right.
State your name for me, please, sir.
Charles Campbell.
Thank you, Mr. Campbell. Today is the day and time scheduled for their preliminary examination in this matter. There is count one, domestic violence, third offense. Are the people prepared to proceed?
Your Honor, it is a good issue that pertains to our preparation to proceed. As Your Honor noted, I'm here, which is kind of a rarity. APA Mandernack, who's assigned to this file, fell ill this morning. I received a call from her at about 7 o'clock indicating that she had some food poisoning and wasn't able to make it in. So I'm taking over with incredibly little notice. I have spoken with the officer in charge, who is actually not the official officer in charge. Detective Rice is here today. Carolyn Williams is the officer in charge, and she is also out. It looks like there was some communication issues or some errors in attempting to get the subpoena served on the complainant. I know that Carolyn Williams, Detective Williams, had spoken with the complainant. I just spoke with the complainant on the phone. She was confused about the date and confused about whether or not she was in fact being subpoenaed. She is currently at work, and she works in the medical field in an emergency room and cannot make it. Because of all of these developments in the case, the people are going to request a brief adjournment in this matter so that we can get this cleared up. And I apologize to the court. It's not how we like to do things, but we are desiring to proceed. It's the desire of the people to proceed with or without the cooperation of the complainant. Were this matter to be reset, we would be subpoenaing the responding officers as well as the complainant in anticipation of an examination.
Thank you. Mr. Bradford.
Yes, Judge, I'm objecting to the adjournment, asking for a dismissal. This exam was set on May 22nd. It has been almost a month and a half that they have had time to subpoena this witness to bring her here today. So I would be asking for a dismissal instead of an adjournment.
Thank you. Anything else, Mr. King?
No, Your Honor, thank you.
Thank you. The court having the opportunity to hear the parties in this matter and having had contact from APA Mandernack this morning indicating her unavailability, the court will find good cause to adjourn this matter over based on the illness attributed to the assistant prosecuting attorney, along with the issue in subpoenaing the complainant. This is a relatively new or new case. There has been minimal appearances. There was an earlier confusion regarding Mr. Campbell's being transported. So charged to both sides at one point or another during the life of this case. We will reset the exam for. Oh, we have a problem. We are rotating off of the criminal docket. We don't come back on until August the 7th. And I think we have availability on August the 14th at 11 a.m. Mr. Bradford.
I'm in a capital jury trial, pretty much that entire week.
And then we're next up September 18th,
Also in a jury trial,
25th,
in a jury trial.
October 30th.
I will also be in trial.
November 6th.
I am available, Judge, but just for the record, this is well outside the statutory requirement to have the preliminary exam within 21 days. I understand your ruling adjourning for cause. I'm just making the record.
I understand, Mr. Bradford, and the court did offer earlier dates at which time defense counsel is not available. So it's, I mean, we're trying. If you have a suggestion for something different, I'm happy to take it. Otherwise, we'll put this case over to November the 6th at 11:30. November 6th, 2024 at 11:30 a.m. back here in person in courtroom number 1. Mr. Campbell, please accept my apologies that we do not typically adjourn cases out that far. It's just the court scheduling, your attorney's unavailability. There's conference coming up. We don't typically adjourn things out, but I appreciate your patience and yes, sir.
I will address it. He is on a GPS tether and he will be required to be on a GPS tether for 4 months and we adjust.
So make your motion.
Judge, as we're setting this out for 4 months, I would request to adjust the bond to remove the tether as this time. He is going to have to pay for that tether between now and that November 6th date. He did appear for court today. As you noted, the only time I believe that he did not appear in front of you was not his fault. The jail did not bring him over. So I don't think he's trying to skirt this court or his responsibilities and understands the seriousness of this, these charges, and obviously will remain having no contact with the complaining witness. So I would request to remove the GPS tether at this time.
Your Honor, I would note that this is a domestic violence third offense notice case. There is a history here that is not to be taken lightly. Furthermore, there is an active PPO protecting this particular complainant from the defendant. I think in light of all of those circumstances, the bond is more than reasonable. However, if Your Honor, in light of the delay, does believe it's appropriate to remove the tether, the people would request no contact be ordered with the complainant, her place of residence, or her place of employment.
Absolutely. This court having had the opportunity to hear from both attorneys in this matter, the court will grant the defense motion to remove the GPS tether. It is my secretary will print out what you need to get that tether removed, to get that information transmitted to the tether unit. But Mr. Campbell, I'm not the one that arranged you, but I want to be crystal clear on what no contact means. No direct contact, no contact with third parties, no contact through social media. Should this court receive reports that you have made efforts to be in contact or communication with the complainant, in this case, Michelle Gutierrez, it will be viewed as a violation of the terms of your bond. Your bond could be revoked and you could spend the rest of these proceedings in custody. Do you understand? Thank you. Anything else, Mr. King?
Nothing further from the people. Thank you, Judge.
Anything else, Mr. Bradford?
Not on behalf of the judge.
Thank you. That concludes this matter. Mr. Campbell, good luck to you, sir. I will see you in November.
We'll talk before that. I'll get the paperwork for it.
If you wait out in the hallway, the officer will bring you what you need.
You did say that was at 11:30, Judge?
Yes, sir.
Okay.
It's the first one. Good to see you, sir. Mr. Gozzi. 194774 FD. This is State of Michigan versus Clifford Watson. May I have your appearances, please?
Good morning, Judge. So on behalf of the people, 87439.
Hey, good morning, Your Honor. This is Sergeant Porter, Rosie, on behalf of Mr. Clifford Watson, please proceed.
At this time, Judge, the people did submit a motion for an adjournment. At this time, in this case, in a crucial witness, Officer James Hillen is out of the state for a prepaid vacation. He will not be back until July 15th. So the people asked for a brief adjournment until he's back.
Because we are, this examination is scheduled back April the 10th, 2024. Today's date, and I would presume that people are vacation times, et cetera, were such witnesses. And this was agreed upon date and time. It's a 2018 case. In addition to that, we've also requested discovery on that. We were informed by the people that the only discovery that was available was what was written on the police reports, that there may have been a body worn camera system back on the date of the incident. However, that has since been purged from the police officers' evidence. So we're kind of behind on that. Nevertheless, though, today is the date scheduled for examination. We object to adjournment. We're asking them to dismiss this case.
Judge, I do, to address first of all, discovery, the people have turned over all discovery that we are in possession of. In terms of the digital discovery, I spoke to the OIC in charge. He's indicated to me, Officer Long, he's indicated that the discovery at the time is from 2019 and they had an old system at the time before this new Axon system that we have now, where it automatically kicks out or kind of deletes cases after 2 years. However, it does not negate the testimony that we anticipate to hear from witnesses, and it would be premature to dispose or dismiss a case before hearing that testimony. In regards to Officer Hillen's time off, we were notified back in April, and there was a motion written in April, on April 10th, and submitted to APA Mohammed, who then submitted it to the court in April, to my knowledge from my notes, and that has been addressed previously. So I'm requesting to understand if the judge knows about this.
Few quick things. You gestured to your left and said long. That is not long sitting to your left. That's number one. Number two, the court did not receive the motion to adjourn today's exam until yesterday at 12:42 p.m. And the motion indicates only that Officer James Hillen will be on a prepaid vacation on the day of the exam, July 3rd. So if your indication in your notes are that in April, your office was aware of the fact that Officer Hillen was not available, and Mr. Mohammed being regularly assigned to this court and being aware of the fact that there are limited exam dates 2 times every 6 weeks from this court, and he did not take efforts to have this case moved earlier, the court will deny his request to adjourn this matter, grant Mr. Gozzi's request to dismiss this case. This dismissal is without prejudice. Mr. Watson, please understand that the people may elect to refile this case. Is there anything else, Ms. Soba?
Nothing from the people, Judge.
Anything else, Mr. Gozzi?
Nothing, Judge.
It was personal bond in this matter. This case is concluded. Good luck to you, Mr. Watson. Have a good afternoon.
Right. And of course, the dismissal, we can get that through the register of actions, correct?
Correct.
Thank you.
That's okay.
I know. Thank you.
For the vendor. Where's the sound? Paul?
Yeah, it's all three guys. Yeah.
12 o'clock. I was gonna say, should I even leave?
you're gonna call Perkins case as soon as Mary Ann comes back.
Okay.
I don't want to.
So. Watch him fly out of here. Yeah,
You're here with all your friends in here.
Yeah.
Not Detective Long, right?
No, not today.
Two four zero four FY, State of Michigan versus Justin Perkins. Your appearances?
Good afternoon, Your Honor. Natalie Abner requesting permission under MCR 8.120 to conduct this hearing under the supervision of Attorney Donna Silk. 87439.
Permission granted. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, entry without breaking with intent, count two, larceny in the building. This case was scheduled at 12 o'clock. It's now 12:18 by this court's clock. How are we proceeding?
Your Honor, the people are ready to proceed. Our witnesses are present. However, the defendant is not, so we are requesting a KPS.
Ms. Henderson?
That is correct, Your Honor. State Henderson with NDS P 84839 here on behalf of Mr. Perkins, who is not present today. I have not had any contact with him. He has response to letters being sent. All the numbers that I have for him are currently not working, and he has not contacted our office since we initially sent our representation letter.
Thank you, Ms. Henderson. Again, this case being scheduled at 12 o'clock, it being 12:18. The exam was set back on May 15, 2024, which time Mr. Perkins' appearance was waived. The prosecution's motion for KPS is granted. Court will set bond at 5,000, 10%. Is there anything else on behalf of the people?
Nothing from the people.
Anything else on behalf of the defendant?
Nothing, Your Honor.
Thank you. That concludes this matter. Have a good day.
Thank you.
Your Honor.
I have it written down. Not here, but I have it on my.
No one's home when I knock.
What's that?
Mary Ann's here, right?
Yeah.
Yeah, no one's home when I knock.
You need to see her?
Yeah, I got a procedural, just kind of a question. I think we might be able. Zoom, it's not gonna sound- That's it, just. Hey, got a question for you. I think we might be able to resolve these cases by way of. You guys have a form you want me to use for that?
That's a good question. I don't know when.
I can use our standard form.
Yeah, if you can understand, I don't think it's gonna matter.
And if I email that to you,
Yeah.
let me use a standard, let me just generate it as a standard form and see if I can get the ability to take this.
Okay.
And judges are gonna have a problem with this.
No, sir. No problem. Okay, all right.
All right,
Thanks.
thanks, Marianne.
You're welcome. No, that's not happening. So the officer, the court officer is going back. Everybody's here, we're all ready to go. So, and I already spoke with the prosecution, and if you can provide documentation of your illness, I'm sure something is going to get worked out, where you're not looking in jail or prison. Okay? Well, that's fantastic. Are they gonna make you walk back there now? Oh, for God's sake. Hang on 1 second. He's literally in the basement of Frank County. You can't see him. You cannot. But he called my work cell phone, indicating it was my client, and he knows what he's charged. He's doing great in what he refers to as the facility. Can you attest to? Yes. Yes. Does, let's get, Sobin or Larry and see if they have any objection. Hang on I think we're actually going and when you're walking back to Salvation Army, yeah, you might want to grab a lottery ticket. Because I cannot believe we've figured all of this out. I need the names of those deputies, and I owe them a nice, cup of coffee or maybe a bottle of wine. It shouldn't be that long. I know. And you don't drink a lot of water before you leave out or walking back to Salvation Army. Of course not.
What's the name?
His name is
Dillard. Yeah. What we're doing,
yeah, oh, yeah. So hopefully we'll be done in a couple seconds.
That's right.
I need to answer
Could be here in a minute.
Okay.
My goodness, those deputies are loud.
Well, the rule for today is we're done. We're not.
Okay, so quiet like a church mouse, we go on the record, okay?
My apologies.
And can you ask the rest of the staff there if they can quiet it down just a touch so that the court can hear your voice? All right.
How is he on the phone?
He's literally on a landline in the deputy's area.
Oh, you see that little desk in the front?
Let's try this. Let's try it. Never a dull moment.
You can't say I'm not entertaining.
Ms. Maishan, there's a lot of things I might say about you. Not entertaining was never one of them. These are 240538 FY and 240520 FY. These are both State of Michigan versus Scott Allen James. May I have your appearances?
Good afternoon, Your Honor. APA Larry King for the people on both files.
And good afternoon, Your Honor. Oh, I'm sorry.
P78774.
Sorry, I cut you off.
That's okay.
And Kim Michon, Neighborhood Defender Services, P59167. It's my pleasure to represent Mr. Scott James, who is on the line, Judge. He is in the Frank Murphy Hall of Justice. Apparently Salvation Army just let him out to walk to court, and he thought he had to go to Third Circuit Court. I recognize his name. I've spoken to him previously. This is the gentleman. He will be waiving his right to both preliminary examinations, in that I've told him he has a right to have a preliminary examination where the people would need to establish by probable cause a crime has been committed and he may be involved in that matter. After that discussion, he's indicated he wants to freely and voluntarily waive that right, understanding he will be bound over to the circuit court, and I tender him to you, Judge.
Mr. James, state your name for the record, please. Mr. James, would you give me your address, just the number, not the name of the street?
Salvation Army, Judge.
Before you went to Salvation Army, sir, where were you? Just the numbers, not the name of the street. You understand my question?
I do.
Would you ask it a better way for me?
Sir, prior to your arrest, what was your address? Just the numbers. How about this? Judge?
Close enough, close enough.
Amen.
I
Mr.
can state this for the record, Judge. I communicated with the Wayne County Sheriff's Department tether unit, who confirmed that this particular defendant is in fact at Frank Murphy Hall of Justice right now.
Mr. King, I appreciate that. I respect that. This court's policy is typically, if I can't see you, you can't do anything in this courtroom. Not waive, not plead, not anything. I understand that this is an unusual circumstance. And when we set this exam on June the 26th, I knew that this is what was going to happen. I knew that Mr. James would not present himself to this court. I didn't know it was going to happen like this, but I'll take it. Mr. James, you had the opportunity to speak to Ms. Maishana. You understand why we were supposed to be here this afternoon? Would you?
May I approach?
Absolutely. All the way up here for me, please. Mr. James, you've had the opportunity to speak to Ms. Maishana. You understand why you were supposed to be here this afternoon?
Yeah, it was supposed to be a prelim or something like that.
And sir, you wish to waive your right to have that preliminary examination?
Yeah.
And you,
I can't make it right now.
I understand, sir. And you haven't been threatened in any way or promised anything to get you to waive the exam?
No.
You're doing so freely and voluntarily?
Yeah.
And you swear or affirm that everything you've just said to this court is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. James, the court will find that your waiver of this preliminary examination has been freely and voluntarily given. The next step in these proceedings is that I will pass your files to your attorney. She will sign that you are waiving your right to have the examination. I will also ask Mr. King, the prosecuting attorney, if his office has any objection to your waiver.
Your Honor, I have no objection to the waiver.
The court having found that the waiver has been freely and voluntarily given, the prosecution having no objection, the court will have the attorney sign the waiver form. I will then sign the waiver form. The next step in these proceedings is that you will be bound over as charged in both files. Your next appearance date, he's considered in custody even though he's with Salvation Army?
Yes.
Yes.
Oh, I'm looking at you, asking you. Sir, your next step in these proceedings will be an arraignment on the information, which will be next Wednesday, July the 10th, 2024 at 9 a.m. Your previously entered bond with any of its conditions will continue. Anything further, Mr. King?
Your Honor, I would ask, I'm a little troubled by the fact that this defendant who was supposed to be in residential treatment was just let out to walk to court. I would ask that the court order that he immediately return to Salvation Army and that he check in there no later than 4 o'clock tonight.
I have no objection to that, and he has indicated to me he is doing remarkably well and wants to thank the court for allowing him to get into treatment.
Mr. James, at the conclusion of this case, when you hang up off of that phone in the jail, the next step is that you must immediately return to Salvation Army. Immediately means report before 4 p.m. today. Is there anything else, Mr. King?
No, thank you, Your Honor.
Anything else, Ms. Maishan?
No, Your Honor, thank you so much.
Thank you. Mr. James, you're free to go. Safe travels to you, sir.
Thank you.
And thank you for your special dispensation.
Thank you, Ms. Maishan.
Well,
The alternative was unacceptable.
Exactly, for all parties.
Thanks, Tom.
Oh, anytime.
I'm not gonna be there for the AOI.
Can you have what?
I'm gonna be out of
Oh,
town,
yeah, thanks.
but-
This is another one.
Thank you, I
It's a no.
appreciate it.
Failed to appear, yep, which I'm surprised by. He usually appears.
Is that going this batch?
Yeah, in just a second. Are you on your way downstairs?
No, that's okay. I'm trying to hustle them along.
I know. There was 24L023113OI. This is State of Michigan versus Priority Waste. This case was scheduled at 9:15 a.m. for a pre-hearing. It's now 1:37 p.m. The defendant has failed to appear. Based on his failure to appear, the fall judgment shall enter in this matter. I thought they were just signing something. I thought that the 12 o'clock case was just signing something and it would be right in.
Well, yeah,
Okay,
he's still talking to his client.
no,
Where he was when he came in, so.
like
I'll try to
7
get
minutes
them
from now.
in.
No, at 1:45, they need to be physically in this courtroom.
Okay.
Thank you. Thank you.
I was told you wanted.
Well, what I told him to convey to you all is that we need to get going on the 12 o'clock case by 1:45 because my 1:30 case, and we're trying to get out of here at a reasonable hour, not the 5 o'clock that we left last Wednesday. So not you that I want, just want the case to get going.
On that, the 12:30 case, a plea offer was made. And given to Mr. Picker, or not Mr. Dillon, who is down the hall for this one.
I understand.
Okay, so it's not.
It wasn't you that I wanted. It was to get going so that we're not here. Our last case is scheduled at 2 o'clock. At 2:30, these lights are going off, so. I have not seen him, but I haven't been in the front hallway. If you haven't seen him on the mezzanine. Mary Ann? Okay, you ready? Thank you. Good afternoon, sir. How are you?
Pretty good on Stam.
Yes,
It'll be over.
it'll be over? A hold, okay. Did you convey that to Mr. King? Okay. The issue is that your case was scheduled at 12:30. Is the 1:30 case here?
Which one's the 1:30?
Grissom.
The complaining witness is present. I have not seen the
It-
defense.
As long as the defense is not here, we're prepared to proceed. If we are ready,
May I have just a minute to get my file pulled up on the computer for this matter?
absolutely, sir.
Okay.
Were you surprised by the phone number or something?
Ready?
This is 240354 FY, State of Michigan versus Geraldine Stam. May I have your appearances, please?
Good afternoon, Your Honor. APA Larry King for the people, P 78774.
Joseph Dillon, P 37225, on behalf of Stam.
Your name, ma'am?
Geraldine Marie Stam.
Thank you, Ms. Stam. Today is the day and time scheduled for the preliminary examination. In this matter, there is you may be seated, ma'am. There is count 1, assault with a dangerous weapon. There is count 2, domestic violence, which is the misdemeanor traveling with it. Are the people prepared to proceed?
The people are prepared to proceed to examine this time. The complaining witness is present. I will note that I did have a discussion with Mr. Dillard. An offer was extended in this case. That offer will be revoked if the exam runs. There will not be any further offers at this time.
Defense prepared to proceed.
Yes, Your Honor. I've had an opportunity to explain the plea agreement to my client. She's had an opportunity to review the offer. And that was basically in this particular case, dismissing count 1, pleading guilty to count 2, domestic violence pursuant to MCL 769.48, no contact with Jeffrey Dotson, having to complete psychological evaluation, follow all recommendations for treatment, complete substance abuse evaluation and follow all recondition for treatment. Defendant must complete an approved anger management program, no alcohol or non-prescribed drugs, random drug and alcohol testing at the discretion of probation, restitution, fines and costs as determined by the court at the time of sentencing. And that would be keeping this case here at the district court and not having this matter proceed to the circuit court on the felony charge. This offer expires at 4 p.m., 7/3/24. She indicated that she does not wish to accept this offer. I would like for her to make a statement on the record. Do you understand the offer that was given to you?
Yes, Mr. Dillard.
And what is your position? Do you accept it or reject it?
Reject it.
Understood. Any other you may be seated, ma'am. Any other preliminary matters, Mr. Dillard?
Your Honor, with respect to this particular matter, I would ask for sequestration of the witnesses in this particular case. And I'm not certain how many are testifying today.
Absolutely. Let me do the first part first. The defense motion for sequestration is granted. If you are in this courtroom and intend to give testimony in this matter, not just today, at any point in the future, please exit the courtroom. Secondly, this court streams this proceedings. If you are listening to, watching, or otherwise taking in these proceedings, and it is possible that you will be called as a witness, not just today, but at any time in the future, you are to cease viewing, listening to, or otherwise taking in the information relative to this case. The question was witnesses.
There's one witness that I intend to call today, Mr. Dodson. He is present. The person in the courtroom will be a representative from the police department. And I would ask for an exception to sequestration for the person serving as our officer in charge today.
Is the officer in charge a witness in this particular case?
Only as to the role as the officer in charge, not as to the facts.
No objection, Your Honor. And is that going to be the same in circuit court?
I make the same motion.
Thank you. Anything else, Mr. Dillard?
At this time, no, Your Honor. If I can have just 1 second.
Absolutely. You see Tyrone in the hallway? Okay. Why not? Anything else, Mr. King?
No, Your Honor.
Your first witness, sir.
Your Honor, people will call Jeffrey Dodson.
Mr. Dodson, come forward for me, please, sir. There's a podium here in the middle. I want you to come up here, please. State your first and last name and then spell them both.
Spelling both.
Yes.
Jeffrey Dodson, Your Honor. Jeffrey Dodson, DOTS1.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Thank you much. You may put your hand down. You're going to come have a seat in this black chair that's closest to me. My secretary is recording your testimony. If she's unable to hear you, I'll ask you to either raise your voice or to move your body closer to the microphone, okay?
Okay.
Thank you.
Yes.
John, just one question. I see a green light. Is the mic live at the defense station?
Yes, sir.
Is it possible? Okay, thank you very much.
You're welcome. Yes, sir.
So, Mr. Dodson, I am going to ask you some questions. If you don't hear me, you don't understand me, tell me, okay?
Yes.
And if you give me an answer, we're going to assume that you meant to give that answer, right?
Right.
So if you don't understand, you'll tell me you don't understand. Is that correct?
Yes, sir.
The other thing to know is that we'd have to do this in a question and answer format. So when I give you a question, answer it in about a sentence and then stop, okay? We can't have you just talk out, okay? Does that
Sure,
make sense?
yes.
So, sir, how do you know the defendant, Miss Jerry Lynn Stam?
I met her at a AA meeting.
When was that? About approximately.
Approximately, let's see, approximately in April, let's see, 2023, I believe.
Sometime in 2023.
Yes, sir.
And thinking to the date of the incident, April of 2024, specifically April 13th of 2024, what, if anything, was your relationship with Ms. Stam at that time?
We're starting off as close friends.
And did the relationship ever develop to anything more than being close friends?
We were starting to be like girlfriend and boyfriend, I would say.
Was there ever a time when the two of you lived together?
Yes, when I moved her, she wanted to move out. She had broke up with her boyfriend. And she suggested that if I moved, she moved out, she would move into my home. I suggested that I would take her into my home.
And do you remember approximately when she moved into your home?
Let's see. Sometime in late 2023.
So this person who you've known since 2023, who at one point in time lived in your home, that we've talked about as Miss Stam, do you see her somewhere in this courtroom today?
Yes, sitting right over there.
So you're pointing in the direction of
Jerry Lynn, right there in the front and left side.
Can you tell the court something identifying about what she's wearing?
She's wearing glasses and a black shirt.
Will the record reflect identification of the defendant?
Yes, sir.
So did there come a time when she was to move out of your home?
I didn't know anything about it until she just disappeared for a week. I was texting and asking our friends at the town AA that we were attending, New Boston, where I live. And
So let's back up for a second. Do you recall the reason we're here in court, the day that brings us to court? Do you remember that day?
I'm sorry, sir, could you ask the question again?
Do you remember the events of the day for which we are now here in court? Do you remember the day that we're here talking about?
The events? Yeah, it was in April of 2024.
So thinking specifically to April 13th of 2024.
April 9th or somewhere around there. I think April, actually, let's see, mom was up on her birthday, April 15th. So it was early April 2nd or 9th. I'm not real sure on that one.
Was there a date in early April when you had police contact?
Police contact?
Yes.
Only when I called them, because I was asking Jerry Lynn to leave the home. When my parents were there, because she had come back from that 5-day excursion when she took off and said she was moving out from the house. And I told her, why don't you just wait? And she refused to wait.
Okay. So that was in early April of 2024, correct?
Yes, sir.
If the police reports indicate that that contact was April 13th, would you have any reason to dispute that?
Objection, Your Honor.
No, sir.
Give me 1 second, Mr. Dawson.
You suggesting the answer. I would ask that the cast recollection independent, so be it. But as presented, he was basically suggesting the answer. I would ask that it be stricken.
It's a foundational matter. I understand it was a leading question, but it's a preliminary and foundational matter. It relates to the date and time. If the court wishes me to rephrase, I can.
Would you please, Mr. King?
Okay. Do you have any independent recollection of approximately what date this was?
Maybe April 2nd. I got it on my phone, actually. Some of the time, I believe.
But you are confident in the month of April in this year, 2024?
Oh, yes.
Okay. And on the day, this particular day on the month of April in 2024, were you at your home?
My home, yes.
And what is your address?
24077 here on River Drive, New Boston, Michigan.
And was the defendant there?
No, that's when she showed up.
Okay. Do you recall about what time of day she arrived?
Somewhere around 2 o'clock p.m.
What's the first thing you remember once she got there?
She got out of her truck and she's in a rage, wanting to barrel into my house.
When you say she's in a rage, can you describe for us exactly what you saw that made you believe it?
Yeah, she's just barreled in without saying anything and trying to push me out of the way one time and pushed me into my sump pump and broke it. And there was a scratch on my arm. And then the second time I was on my back porch on my door and she swung her, whatever was on her keys and cut my wrist. The scar still there. And it was bleeding.
Mr. Dawson, give me 1 second, please. I'm sorry.
The witnesses becoming narrative, if there's specific questions, no objection, that would be the case, but right now you just narrate.
Understood.
So, Mr. Dodson, remember what I said to you at the beginning, give me a sentence or two, stop, and then we'll move on, okay?
Okay, sorry.
So she
Yes, sir.
came to your house, right?
Yes, sir.
And you indicated that she entered your home, correct?
After she knocked me out of the way, I told her to leave.
So let's talk about that. She comes to your home. Does your home have more than one door?
Yes, sir.
Okay, tell us about the doors to your home.
I got one going through the garage in the front of the house and then one going to the front door.
Okay, so she comes to your home. Where are you?
We're putting brakes on my truck, me and my stepdad.
Okay, so were you inside, outside, something?
Outside.
Okay.
The garage.
And
Go ahead.
where is she when you see her?
Pardon me, sir?
Where is she when you first see her?
She's driving up the drive and then she gets out of her truck and starts heading toward the house.
Okay,
To
so
go
she's,
in.
let's stop right there. She gets out of her vehicle and is headed towards the house. Which door is she headed towards?
Toward the back door through the driveway, through the garage to get into the back door.
And what, if anything, do you do?
Pardon me?
What do you do?
I try to talk to her to get her to stop. And
And where does that conversation happen?
right there by the back, when the garage door's up, right there before she gets to the back door.
And what, if anything, happens after that conversation?
What if anything happened?
Yeah, what happens after that conversation?
I got pushed into the sump pump first and broke, and I fell into the sump pump. I broke my leg.
Where is your sump pump located?
To the right of that door in the corner.
So it's in the garage?
Yes, one of them, yeah.
Okay. And where in relation to the sump pump were you?
I was like in front of it.
Okay. And where was she?
She was in front of me,
And what specifically does she do?
trying to get by me. And the only way to get by me, because there's stuff in the way, is knock me out of the way.
Now,
Get to the door.
you fall, correct?
I had no other choice, yeah.
And what happens after you fall?
I fall into the pump. I fell backwards like this. I would put my arms up because I wasn't gonna hit her or stop her. I was trying to say stop. Fell back in the sump, it broke and it hit something that cut my arm, that I think was a bracket.
Okay.
And I got scar there still.
What happens next? What happens after you fall into the
But, she got her way past me because I fell down, proceeded toward the back door.
And what do you do when she proceeds towards the back door?
I went to the back door and got in front of her.
And how is she acting at this point?
Erratically.
When you say erratically, can you give us an example of something that she's doing?
Yeah, just not in control. I mean, not listening. Anger.
What's the next thing that you remember happening?
Her swinging and punching and swinging with that device, whatever it was.
Just for the record of the court, the witness has his left hand in a fist out in front of him, making an up and down motion. Is that accurate with what you were doing? Does that describe what you were just doing?
She was doing.
But that's what you're doing right now, right?
That's what she was doing.
And when she was doing,
Your Honor, as a courtesy, from this court, I understand technical installation and everything. However, I'm not able to see the witness whatsoever.
so
Mr. King, you can't, I heard you, Mr. Dillard. I appreciate that. You cannot stand there because she can't record you. Our microphones record, they don't necessarily amplify that much.
if I stand here, can I use this microphone?
Yes,
Is that okay?
Oh, no problem.
and we need to pick up the pace. We need to be done with this by 2:15.
Sir, can you do again for me what you were just doing with your hand? And will the record reflect that the victim was, or Mr. Dodson had his hand in the fist, his left hand in the fist, out to his side, was swinging it in front of his body?
That's an accurate representation of what happened.
Did she have anything in her hand at the time?
Yes,
What was in her hand?
a ball, keys, and I don't know what else. It was a lot. Could have been a John Wayne little hand knife,
Objection,
whatever
Your
it
Honor.
did. Cut my-
Motion to strike speculation in terms of, it could have been, that's pure speculation.
Whatever it was. it cut my
Mr.
hand.
Dodson, I understand, but just as a procedural matter, the objection sustained. Mr. King will ask questions in a different way.
And if the response as it relates to, this speculation is stricken.
Yes, sir.
So did you see an object in her hand?
Yes,
Okay, do you recall specifically what that object in her hand was?
yes,
What specifically was in her hand?
her keys.
Okay. Are we talking about one key or?
I couldn't make a accurate count on that, but there's a lot.
And you said, did those keys make any contact with your body?
Yes,
What
definitely.
specifically happened? What
It
specifically-
cut me. I felt it go across and I seen it gushing of blood. It almost cut my vein right there.
And just for the record, when he's saying right there, this witness is pointing to his left wrist.
And it's still there, obviously. It was bleeding like stuff.
Your Honor, as an objection in terms of the speculation, in terms of almost cutting my vein, unless he has some medical experience, at this point, I would say it's speculation. If his arm was cut, if he understands his arm, no objections to that. But in terms of the particulars that he's going to, unless there was a medical report, and I have no medical report at this time.
I'm fine with the term, she almost cut my vein being strict, Judge. I'll stipulate to the striking of that.
Thank you, Mr. King.
Your wrist was cut, correct?
Yes, the police told me to go to the hospital, to call ambulance. I wrapped the towel.
Did you go to the hospital?
No, because I said, I looked at it, it wasn't cut, but it was really deep. And I wrapped the towel around it and said, I've had worse cuts. So
And you still have a mark from this.
yes,
And did you call the police?
oh, yeah.
At what point in time did you call the police?
Yes, sir.
What point in time? When did you call?
We had called him before.
We,
Yeah, my nephew was there.
your nephews.
He
Was
took,
it you or your nephew who called?
I believe my nephew. Yes, my nephew.
Presently, if you call.
Yes, it was. And he talked to the police too.
I have nothing further from this witness. Thank you.
Thank you. Mr. Dillard. Yes.
Yeah, no objection. I mean, I have that picture, so that's fine.
And I have what is marked as defense exhibit A. I've had an opportunity to speak with Brother also.
That's okay.
With Brother Counsel, and she stipulates to the admission.
Accurate.
Defendants A will be received.
Thank you. I'd like to show you what's marked as defense exhibit A. Is that your garage?
Yes,
Now, you indicated that Ms. Stam came to your property
yes.
and she was living there as well, correct?
I let her live there.
Okay. And with respect to that exhibit, is that the entrance of a garage?
That's the side of it. Yeah, the entrance, you can see it right here. There, a little bit of it, the left side.
Okay, now when she came to the property, where was she standing before she entered into the property?
She was standing on the outside. You can't see where she was standing.
Okay, was it more in the middle, more to the other end of
There was, no, that's just the driveways was all real long.
Okay, but when she came into the garage, did she come into the garage?
Say that again, sir?
Did Ms. Stam enter the garage?
Yes,
And when she entered the garage, is that visible in that picture where she may have entered?
push me in that sump pump right there. Is that what you're asking?
Anna, move to strike the response as non-responsive.
It's stricken. Mr. Dotson, I need you to respond to Mr. Dillard's specific question.
I
And if you don't understand, just say, don't understand. I understand you. Mr. Dillard, if you want to ask your question again, sir?
Well, when she came into the garage, where did she stand when she first came into the garage?
Right there, that's the corner, because I was blocking her right there when she came in that front. That's the left side of the garage. It's a 2.5 car garage, so she was right there where you can see the outside, that brick. She came in there first because that little bit was open. The truck was in the front of that, and we were putting brakes on.
Now, how did you, when she came in, where were you standing when you say you blocked her? How did you block her?
I just stood there and was talking to her, trying to get her to not, try to talk sense.
So that's all you did was simply stand there and talk?
Definitely, I did.
Did you block her with your body?
Nope, stood there normal, trying not to. I didn't do no hitting, no swinging, no grabbing, nothing.
Did you put your arms out?
No, I put them down, just like I said, don't.
Okay, you say down like this?
Just regular, like somebody would
So
do.
you had your arms out?
I don't remember if I had them out or not. I just.
Well, you just indicated, and
Normal.
the record reflect that he had his arms out at chest level, to the both left and right arm held out to the side with open palms facing the front.
I might have
Now,
been
sir.
holding them down on my side,
Sir,
saying normal
sir.
body language.
Objection, Your Honor. Move
Mr.
that it be stricken as not responsive.
Correct. Mr. Dotson, I understand what you're trying to do, but I need you to respond just to what he's asking you. Don't go beyond your response to his question, okay? If that makes sense to
Yes,
you.
Your Honor.
Thank you.
Is it stricken, Your Honor?
Yes, sir.
Thank you. Now, when you put your arms out, you were standing where in relationship to the sub pump? In front, between the door, the back door, and the sub pump, or in front of the sub pump to the opening in the garage?
In front of the sump pump to the opening of the garage.
Okay. And how far did Ms. Stram enter into the garage?
She couldn't get by me, so she had to force her way into me.
Again, kind of non-responsive. I'll move for script to strike. And I'll give my question again, and that was, in terms of your, as a matter of fact, could the court clerk, she able to recite the?
She's not. It's recorded. It's not.
Oh, okay.
So,
Let me rephrase.
thank you.
When she came in, was she in front of the sub pump?
No,
Was the garage, was the opening of the garage to her back? Or was there the opening to the door?
the sub pump wasn't back of me. She was in front of me.
Okay, now, how long did you talk?
I would say just a few seconds because she was
How long did you talk?
just a few seconds.
Now, with respect to you putting up your arms, did Miss Stam ever fall into the sub pump?
No,
And with respect to the sub pump, did you ever try to assist her out of that sub pump? Yes
she
or
never
no?
fell in the sub pump. I did.
Now, in terms of, you indicate that your injuries, you were injured, by the sub pump, correct?
Who's entering you, sir?
You got injured, you indicated you got injured by the sub pump.
Yes, sir.
Where were you standing in relationship to the sub pump?
Right in front of
Objection,
it.
Your Honor, this
By
has
the-
been asked and answered, I believe, 3 times.
Oh, yeah.
He was in front of the sump pump.
Your Honor, I'm asking in terms of, he says he fell into. So, I mean, if he falls into the sub pump over here, then he can be way over here, he can be way over there. I'm just trying to understand the dynamics, physical dynamics of where he was in relationship to the sub pump.
Further, Judge, the incident at the sump pump is essentially the misdemeanor component of this. The incident the people will allege that occurred with the keys is the felony. So I'm not sure how much longer we need to go into this, but I will say the question of where in relation to the sump pump were you standing was asked and answered 3 times.
Mr. King, the court concurs with you. Your objection is sustained. Mr. Dillard, let's move on.
Now, did you block Ms. Stam from going in, and did she fall into the sub pump?
No.
After that occurred?
No, never. She fell in the sub pump. It was me that fell in the sub pump.
Did Ms. Stam suffer any injuries?
No, none.
Falling into the sub pump?
None.
Going to object, he's already answered the question about Ms. Stam falling into the sump pump. In the negative, there's been no evidence that she fell into the sump pump. And this last question assumes facts not in evidence, the fact that she was the person falling into the sump pump. I just think we're going in a direction here that's beyond the scope of the exam as well.
Your Honor, in terms of him being present, I believe it's appropriate for him to make, if I ask that question, if she fell into that sub pump, that he has while he's on the stand, he can indicate whether she did or not.
He has said already no. He said it early on in your cross-examination.
Thank you.
You're welcome. I'm sorry, Mr. Dillard.
Who was present at that, in the garage?
just myself and Jerry Lynn at the time of the garage incident.
And what about did you say your stepfather? or
Stepfather was working on the brakes. He never moved, just kept on working on the brakes.
And what is his name?
Troy Skidmore, married to my mom.
Could you spell that?
Troy, Skidmore is Skidmore.
And what city and, yeah, I don't know in terms of the addresses.
They live in Nashville,
If you could
Tennessee.
Write it out for the board, or if he could make it on the record.
He said Nashville, Tennessee.
They live in Nashville, Tennessee. They was up here visiting. My mom was celebrating her birthday.
Yeah, Yanni may be a rest eyewitness, and so I would like to have the ability to get in contact with him, but I don't want to offend the court's policy regarding letting out sensitive information.
I understand. I appreciate that, Mr. Dillard. So if Mr. Dotson has that information, more detailed name, street number and address of your mother and your stepfather off the record, please.
Okay, that's the integrity of counsel.
Thank you.
And I would like to have him added as a that information that can be given to. Now, you also indicated that there was someone else there. Who was that individual?
That's my nephew,
And what's his name?
Jesse Dotson.
Okay. And was anyone else there?
No. Oh, yeah, I'm sorry, sir. There's my mother and sister,
In terms of being outside.
but they were gone at the store at the time.
Okay, so they were not present at that time.
They were at one time she came back to the house, but not during that incident, no.
Okay. Did she come back to the house, again, she being the Stam,
Yes,
afterwards, after this incident?
yes,
occurred?
yes.
Is that, how long did it take you to notify the police?
After she came back, I kept telling her to go, but it was gonna give her a chance, go, do this later, it's not a good time. And she wouldn't
So
insist.
around, what time was that?
It all happened about 2 or 3 o'clock. It happened consistently. She kept calling me and texting me and saying, I'm coming back. And I told her to wait. She said she had an apartment, but she didn't have one. I don't know if she put down a deposit on it, but she didn't have one, so there was no sense in doing it.
Okay,
So-
now, in terms of, as Jesse Dotson, is that correct?
Yes, sir.
Yeah, I have a redacted witness list if the prosecution can provide the address of this individual. to
I
me.
still keep him out of it, sir. He's,
I would
Mr.
appreciate it.
Dotson, give me one moment.
I would, being a rest just that witness, I would like to have actual contact information with Mr. Dotson.
Mr. King,
Your Honor, I do not have a street address. I do have a phone number. I will provide that to Attorney Bickert now.
Again, I would like to have the address.
I do
Mr.
not
Dillard, I think
have-
it's clear that Mr. King says he does not have the address. He has the phone number and he will provide you with the phone number.
Well, I'm speaking in terms of the prosecuting attorney's office. He's an agent of the prosecutor's office. What he may not have right now, if that can be provided to me, it doesn't have to be provided to me right now.
Understood.
But I would like that information given.
Your Honor, Mr. Dillard is right. When there's a race just a witness known to the people, we have an obligation to disclose that information and at the request, share the contact information that we have with the defense. I will do that. What I am not obligated to do is to go hunt him down and learn more about him and conduct additional discovery on behalf of the defense. I will share what I have, which I have done. And obviously, if the date and time comes for trial and Mr. Dillard wants him subpoenaed, we have a legal obligation to assist in that as well.
Your Honor, I'm not trying to get everything before the conclusion of this hearing. I'm requesting that I get that information. I'm going to request after this hearing as well, a formal discovery order from this court as well as the subsequent court. But at this time, as it relates to the exam, I just wanted to let the court know that I don't have that information. I would like to have
Mr. Diller, I believe that Mr. King has already indicated that he will give you what he has. That's number one. Number two, it is now 2 hours since your exam was scheduled to start. I'm going to ask you that we move along, please.
Thank you. Your Honor, at this time, no further questions.
Thank you. Any redirect, Mr. King?
No redirect, no further witnesses.
Mr. Dodson, thank you for your testimony. You're free to step down.
Thank you, Your Honor.
Thank you.
Your Honor, the people moved for bind over on the sole felony count of assault with a dangerous weapon. The people further moved to amend the dates and times of the information to be some date between April the 1st and April the 30th of 2024, as the date was uncertain. Your Honor, there was testimony from the complaining witness that there was an altercation between him and the defendant on the date in question, that she armed herself at some point in time with keys, that she took those keys in her hand and made a gesture in the direction of the defendant, and that key did strike his wrist,
Your
causing.
Honor, I apologize. At this time, I recognize that the witness is complaining. However, for the integrity of the process, I would ask that he's testified that he is subject to testifying in circuit court, that he be allowed to not be present during this closing argument of brother counsel.
Your Honor, once the complainant has offered testimony in a case pursuant to the Michigan Crime Victims' Rights Act, he may remain and observe the remainder of the proceedings. However, if the court orders me to ask him to step out, I have no problem with that as well. I was just about done.
Your Honor, with respect to the statute, he has been notified of this proceeding. He has been present.
Mr. Dodson, would you step out, please, sir? Would you please step out into the hallway?
Yes, Your Honor.
Thank you. That is not my typical inclination, but I'm trying to get us where we need to be. Mr. King, if you want to resume your argument, please.
Thank you, Judge. There was an injury testified to as a result of being struck with this object in the, sorry, I'm not used to having my arguments interrupted. Give me a moment. So there was an injury which the complaining witness testified to. Your Honor, obviously, it's assault with a dangerous weapon. It's a probable cause standard. Keys can be a dangerous weapon. They did, in fact, cause injury to the complainant's wrist in this case based on his testimony. And there has been no testimony controverting the story of the complaining witness. I believe it's been shown by a probable cause standard that this defendant did commit an assault on this witness with a dangerous weapon, in this case, keys, in April of 2024 in a location within the jurisdiction of this court.
Your Honor, with respect to this matter, defense is moving that the charge of felonious assault with a dangerous weapon be dismissed, that there is no probable cause to believe that that crime was committed. Even the witnesses testified that that cut, he's had worse than that. He did not seek any medical attention right away. Later on in the day, in this particular case, he indicates that he got injuries from falling onto a sub pump. That fall sounds more like accidental. In terms of the keys, he was making gestures that she was swinging, using her hand. But in this particular case, Your Honor, there's no indication that the injury was such that it being benign, he is not typically a dangerous weapon such as a gun, that as it was used in this particular case, it was not a dangerous weapon. And as there's nothing to support the seriousness of that injury. If it be an injury, the law allows for a assault and battery to have injuries occur. But just because there's an injury does not mean that it was with a dangerous weapon. And yeah, I don't think that they crossed that threshold to indicate that how these keys were used as a dangerous weapon pursuant to the testimony. I would ask that the felonious assault be dismissed. I would ask that if the court wishes to amend the complaint to domestic violence, that's already pled in the pleadings. And I believe that that would be appropriate in a case like this. So I move for dismissal in this particular case. It hasn't been shown that as used that the keys were a dangerous weapon as used.
Mr. King.
Your Honor, the testimony was clear that the defendant had the keys in her hand and was using them in an offensive manner. As the court is aware, anything can be a weapon if used as such. And in this case, we have keys, which are metal objects of a certain size. They were in her hand. They were swung at the complainant. They did cause injury. Now, the fact that injury was caused is not even an element of FA. In fact, simply using an object as a weapon that could potentially cause injury in places would interfere with that object. It consists of assault. The injury just goes to bolster the claim that the keys were in fact a dangerous weapon. I'll rest there, Judge.
Thank you. This court having had the,
Your Honor, may I? There's just an objection to the statement that the keys being metal. There was no evidence that the keys were metallic. No testimony that the keys were metallic. And I believe that it would be inappropriate for the court to automatically presume that the keys were metallic. I would ask that that be stricken. There was no evidence on that. And again, I would ask that, well, I just go to that one statement. I've already made my other points.
Your Honor, at the preliminary exam stage, as the court is well aware, Your Honor is allowed to make logical inferences from the evidence using your own common sense. And we're talking about keys.
thank you. This court having had the opportunity to hear the argument, I'm sorry, the testimony of Mr. Dotson, the argument of the attorneys, court will find that the people have met their burden for this exam purpose, will bind Ms. Stam over. The next appearance date will be an arraignment on the information, which will be on July 17th, 24 at 9 a.m. Her previously entered bond with any of its conditions will continue. Mr. King, is there anything else?
Nothing further from the people. Thank you, Judge.
Anything else, Mr. Dillard?
Your Honor, I request a discovery order from this court if, before I leave. And what's that, the next date?
The date is the 17th of July at 9 a.m. And we don't typically have blank discovery orders available. Is there something specific beyond those, the full address of Mr. Skidmore and the phone number for Mr. Dotson, the younger Mr. Dotson? Was there something else that you wanted?
Yeah, I wish to have everything that's available in this case, videos.
I think that there's a standing obligation of the people to disclose that information, and I believe that Mr. King, as an officer of the court and an assistant prosecuting attorney with the Wayne County Prosecutor's Office, will provide all of that to you, correct, Mr. King?
I can say that the people are in possession of some digital evidence in this case managed through the axonevidence.com system. It is stored in a case file. There are approximately 13 pieces of digital evidence. They have been shared with Mr. Dillard. They were previously shared with him by download link on April the 23rd of 2024, and logs show that that download was sent. And I did again disclose them to him this afternoon, also via download link. And if he still doesn't have them, we'll be glad to send it one more time.
If Mr. Dillard still does not show that those documents is being received, that's something that Mr. King and Mr. Dillard can talk about in the hallway. That concludes this matter.
Thanks, Judge.
Have a good afternoon.
And have a great day.
You too. Thank you. Happy holidays.
Thank you.
This is 240413 and 240530. These are State of Michigan versus Robert Blandon. Good afternoon, ma'am.
May I make a preliminary motion for Mr. Horton, rising real?
Mr. Horton,
Yes.
first and last name for me, please, Mr. Horton.
Caleb Horton.
Any objection from the people? Request is granted.
Thank you, Your Honor.
You're welcome. Where'd you graduate from, Mr. Horton?
I'm currently at Wayne State University Law School.
Undergrad.
Undergrad, Kuiper College. out of
Thank
Grand
you.
Rapids.
These aren't true questions.
I had to think a minute. It's been a while.
Do you need a minute? Are we good? I was leaving and I stepped down weird when I was because I was coming to be fresh and I stepped down. Say something about yeah, I stepped super here. And then Perkins shows up. Hey, Van Buren Township Department of Public Safety is hiring. Yeah. That's all I add today. I'm just letting you know. Bettendorf might be able to help you make a connection there. Appearances, please.
Good afternoon, Judge Stam, so on behalf of the people, PA 7439.
Caleb Horton on behalf of Robert Blandon, who's present to my right.
Serving alongside Emily Elijah, PA 5039. Defendant.
Your name for me, sir?
Robert Blanton.
Thank you, Mr. Blanton. Today is the day and time scheduled for the preliminary examinations in both of these cases. Those cases, Mr. Blanton, recall before you came out of the holding area are 240413 and 240530. Are the people prepared to proceed?
Judge, at this time, I heard you said that it was on, for example, two cases. There is a felony case and a misdemeanor case. Today we're only scheduled for the felony case. The misdemeanor case has a different in-house counsel for Mr. Blanton.
I'm sorry, Ms. Soba, you're right. I see Mr. Reagan's names next to both of those. And you are correct. I was gonna say the 240413 SM is just scheduled for pretrial. Thank you. That having been clear, the exam being 240530 FY, are the people prepared to proceed?
At this time, the people are not ready to proceed. I did speak with the complaining witness in this case. Yesterday, she was ready to be here to proceed with the case. She did indicate that she in this case to go to jail and more so to receive treatment for his underlying mental health issues and to continue on his medication. I spoke with her today. Yesterday, she did tell me she will be here ready to go forward. However, upon speaking to her today, she does not wish to be here. She does not wish to move forward or press charges in this case because she received word that her son, the defendant in this case, actually received a shot to his medication for his mental illness that lasts about 3 months, and that they have been talking to him and he's been through counseling and they're able to resolve it outside of the court because it is a family issue. And for those reasons, she does not want to be here or move forward and would rather he get treatment than go to jail. And for those reasons, the people cannot move forward without their primary witness.
Your Honor, at this time, defense would move for dismissal without prejudice.
No objection from the people.
The defense motion to dismiss the felony case is granted. That dismissal is without prejudice. Mr. Blanton had a 25,000, 10% bond in this case. That is canceled on the dismissal.
And for the record, Judge, the complaining witness's mother, she did indicate that she does not want a no contact order in case. So I believe it'll also no longer be that way.
In part.
Okay.
In
she
part.
For it to be removed, and in lieu of it, a no assault with contact order to be approved.
the court can't order in the dismissed case any contact or lack of contact. The issue is the remaining misdemeanor case that was scheduled for pretrial, the 2400413 SM, has the victim complainant as the stepfather. I understand that, but I'm assuming that
I did speak with her. They want that no contact order still in case for the other case.
the felony case has been dismissed.
Correct.
There's nothing that holds Mr. Blanton to this court any further. The court can't order anything in that case. As for the, excuse me, Mary Ann, as for the 413 SM misdemeanor case that was scheduled for pretrial today, did you have some conversation with Mr. Horton or Miss Elijah about what's happening with that case?
To my knowledge, it is not their case. It's actually MIT attorney Daniel Lasar, who's not here today, does not have an opportunity.
And Your Honor, I apologize. I'm covering for Mr. Riggin, so I apologize for not having the best answers before you today. So I do not have a great answer as to what should happen with that misdemeanor. I'm sure Ms. Silva would also like to resolve that today if possible, but neither of us have the authority to do that. However, I would ask the court, is Mr. Blanton held on that misdemeanor?
He should not be. That case is 10,000 personal, and it's my mistake because on June the 26th, 2024, when we scheduled the matter, I wrote in the file live exam, Mary Ann scheduled it correctly as a pretrial, but Mr. Riggins was here because Mr. Batar had already left for, or was not available. So what we will do is, it's a personal. We'll reset it as a pretrial. 7/10/2024 at 9:30. That will be in person next door in courtroom number 2 with Judge Oakley. Unless there was something else from somewhere else holding him, there should not be anything that keeps Mr. Blanton from being released once he's transported back downtown and to appear in person in courtroom number 2 next Wednesday with Chief Judge, okay? Anything else, Ms. Silva? Anything else, Mr. Horton? Anything else, Ms. Elijah? Thank you. Same to you. Good luck to you, Mr. Blanton. Grissom? Yeah, once you mess it up a little bit, you just mess it, not you, me. It doesn't go off the rails just a little bit. It goes all the way off and to the side. I know.
I'll be right, it's running.
Thanks. Where's Bickert? Mary Ann's doing the transport order. I'm looking for your 1:30 exam. Who's doing Mr. Bickert's case?
I believe that's supposed to be. So with EPAP.
That means you're done, you're ready to go? Go pack for the beach?
I have so much work to do. I have to go. I have like 100 emails that kept coming in all day. I have to go put in all my notes. I already sent subpoenas, respond to everything. Then I'll take a picture.
Thanks for covering for Mohammed.
Of course. Pleasure to be here.
Good to
This
see
is
you.
one of my favorite clubs.
Is it really?
Yes, I love. Let me tell you, Tim, Allen, Garcia, Ken, I love them so much. So every time I come here, I just love being here.
I've practiced in this building for over 20 years now, and it's always been good court officers.
It's like it's bright in here, and everyone's so. I just love it here, so it's nice to be here.
We've come a long way from next door. This is when people come in for the first
I've never
time.
been to the old courthouse.
Are you serious?
My brother works for Delta,
Mhm.
so he's very familiar with the court system because stuff always happens there. Then they come here for tickets or whatever, and he told me that this is really nice.
It is. We've come a long way.
When did you guys?
3 Mays ago.
That's it.
Yep.
Oh wow. very well-run court. It's beautiful, it's clean.
Yeah, they did a good job.
Pleasure to be here. Thank you for having me. And I'll see you when
You'll see me when you see me?
I'll see you when I.
Sounds good.
Have a lovely holiday.
You too. No, we're good. I think Mr. King is ready with Mr. Bickert.
I think we're gonna go. It was finished right before we started. It was 2 years old, it was brand new. I think about 12 or something. Yeah. Good afternoon.
Hey. Good afternoon, Mr. Bickert. You know, you're sometimes on the cusp of saying something, you realize it can wait. It can wait. This is 240337 FY, State of Michigan versus Victor Keith Grissom. Have your appearances, please.
Good afternoon, Judge. APA Larry King for the people, P 78774.
May I please court you on the Tyrone Bickett appearing on behalf of Mr. Victor Grissom, who is present to my right, Your Honor, P number 62647.
State your name for me, please, sir.
Victor Grissom.
Thank you, Mr. Grissom. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, assault with intent to do great bodily harm less than murder, by strangulation, and then count two, misdemeanor of domestic violence that travels with it. Mr. King, are the people prepared to proceed?
Yes,
Mr. Bickert, are you ready to proceed on behalf of Mr. Grissom?
Certainly, Your Honor.
Any preliminary matters, Mr. King?
no, Your Honor.
Any preliminary matters, Mr. Bickert?
I would just make a motion to sequester witnesses.
If there are any persons in the courtroom other than the officer in charge who are giving testimony today or any time in the future in this case, please absent yourself from these proceedings. Additionally, this court continues to stream its proceedings. If you are viewing this court session, listening to it, or taking in the information in any way, shape, or form, and you are a witness in this case, either today or any point in the future, you are to cease viewing, listening to, or otherwise taking in information from this case. Other than that, Mr. Bickert, anything else?
Could I just inquire, because I'm not certain who the officer in charge is, just so that we have a clear record.
You know, the listed officer in charge is Detective Michael Long. However, I believe we have understanding. Was that understanding? Yeah, officer, your name? Detective Bettendorf is here standing there. William Bettendorf and for Detective Michael Long.
Thank
The
you.
complaining witness is present. She is the sole witness on the call today.
Thank
So
you.
I don't think we'll need her to step out, right?
She's fine to stay in the courtroom. Anything else, Mr. Bickert?
No, Your Honor.
Thank you. And Mr. Grissom, you may be seated. Before you call your first witnesses and start thinking about how we're moving through this case, it's 2:44 by this court's clock. We're done here at 3:15. So whatever that means to you all moving forward. Your first witness, Mr. King.
Thank you, Judge. I would call Catherine Grissom to witness.
Ms. Grissom, I'm going to have you come up to this middle podium for me, please. And if you'd be kind enough to state your first and last name and then spell them both for the record.
Catherine Grissom, Katherini, Grissom, Grisson.
Now raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please come have a seat in the black chair that's closest to me. Your testimony this afternoon is being recorded. If we're having trouble hearing you, I'll ask you to either raise your voice or move your body closer to the microphone, okay? Thank you, ma'am. Your witness, sir.
Thank you, ma'am. Could you please state your name one more time for the court's record?
Sure, Catherine Grissom.
Ms. Grissom, do you know an individual by the name of Victor Keith Grissom?
Yes.
I'm sorry for 1 second, Mr. King. Do you want to trade seats with your client or do you want Mr. King to move? Is that helpful? Okay.
Mr. Grissom, why don't we trade seats?
Tell me when I can proceed.
As soon as Mr. Bickert, he wants a line of sight for Ms. Grissom.
Thank you. I'm good. Thank you.
You're welcome, sir. Mr. King.
How do you know that individual, Victor Keith Grissom?
He's my husband.
How long have you known?
35 years.
Now, is he still currently your husband?
Yes.
So your husband, Mr. Victor Keith Grissom, who you've known for about 35 years, do you see him somewhere within this courtroom this afternoon?
Yes.
Can you tell the court where he's seated and what he's wearing?
He's seated next to his lawyer. I think he has on a black shirt.
Record of identification of the defendant.
Yes, sir.
I want to turn your attention to the very early morning hours, about 3 to 4 in the morning, on the 29th of February of this year, 2024. Where were you then?
At my residence of 14215 Red Oak Drive, Van Buren, Michigan.
Is that within Wayne County?
Yes,
And was your husband, Mr. Keith Christen, there with you?
yes,
Is this a residence that you share?
we did.
You did. At the time? did
Yes.
You share the residence? So where in the home were you?
Upstairs on the landing.
And what was happening upstairs on the landing at between 3 and 4 in the morning on this day?
His name was choking me.
Okay. So what happened before that? Was there a?
Before that, I asked him why he blocked his ex-girlfriend on Facebook.
Okay. And where did that conversation take place?
In the spare bedroom where he was.
So he was in the spare bedroom, and is that a place where you are normally at together?
No, that's where he is. That's where he used to be all the time.
So he was there, and then did there come a time when you entered the bedroom?
Yes,
And the two of you had this discussion about the blocking of the person on Facebook that you just had?
yes.
How was he behaving at that?
He laughed at me. He just said, what difference does it make?
And what's the next thing you remember happening?
I asked him if he didn't love me anymore to just please leave. And then he got out of the bed, launched towards me, charged towards me and started choking me.
So when you say that he started choking you,
Mhm.
did he make physical contact with you?
Yes,
What part of his body made physical contact with what part of your body?
his hands around my throat.
Exactly, specifically, how were his hands around your throat, if you could tell us? One hand or two?
Like this.
So just for the record, the complaining witness took both of her hands in C shapes and placed them in front of her near each other, facing each other.
Yes, Mr. King.
How did you feel when he had his hands like that?
Scared.
And is there anything else about the way that you were feeling at that moment that comes to mind?
Scared, sad, and
Were
embarrassed.
you able to breathe?
When he let go?
No, when he had his hands on your neck, were you able to breathe?
No,
How long did that last?
I don't remember.
How did that come to an end?
He stopped and said, you almost got me.
Did there come a time when you called the police?
What I did, he left, started unpacking all his stuff. And then the next day I called an abuse hotline.
Did you have any markings or injuries as a result of this incident?
Not that I can remember.
Did he apply pressure to your neck with his hands?
Yes,
I want you to think about a scale. I want you to think about a scale from 1 to 10. 1 being a light brushing by and 10 being the most pressure you could possibly imagine. On that scale of 1 to 10, how much pressure did he put on your neck?
probably like a 9.
And no further questions from this witness.
Thank you. Mr. Bickford.
Afternoon, man.
Good afternoon.
Ma'am, you stated this occurred on February 29th, about approximately 3 or 4 in the morning, correct?
Yes,
That Mr. Grissom, your husband, was in the spare bedroom where he sleeps, correct?
yes,
You and Mr. Grissom had not slept together in the same room for quite some time, correct?
yes,
Years, correct?
yes,
Okay. And somehow you confronted him about something from his Facebook page, right?
yes.
How did you see his Facebook page and know that he blocked somebody?
From His computer?
Okay, so you went into his computer and then you discovered that you felt that he had blocked another individual, correct?
I didn't feel it, I saw it.
Okay, you saw it, and this would have been whatever individual. And you asked him about this, right?
Yes,
And his response to you, you said, testified to, was that he laughed, right?
yes,
And indicated, what does it matter?
yes,
Okay. All right. Your testimony is then that then you said, well, if you don't love me, then you should leave. And that in response to that, that is all that occurred before he then lunged at you and attacked you and choked you as you described. Is that your testimony?
yes.
Okay. All right. Now, you indicated this occurred on February 29th. When did you report this to the police?
I don't remember.
Okay. If I were to submit to you that police report indicates on March 25th, some 26 days later, that is when you made this report to the police, would you have any dispute that day?
No,
Do you believe that it was weeks later?
yes,
Okay. And you did so by walking into the Van Buren Police Department, right?
yes,
And you spoke to an officer, correct?
yes.
Okay. Did you ever speak to a detective after that?
Detective after that from where?
From the Van Buren Police Department.
I believe so.
Did you ever make any kind of written statement about what supposedly happened?
Yes.
You did?
Mhm.
Do you know where you made that statement?
I gave it to when I walked into the Van Buren Police Department.
Substitute OIC here today, so I can. Oh, somebody's on a message right now.
Ma'am, this written statement that I've asked about and that you testified that you gave, did you write it out in your own handwriting?
No, I typed it out at home.
Okay. And you believe that you provided that to a police officer at some point?
I know I did.
Okay. Did you provide it to a police officer? Or did there come a time where you indicated to the officer that you were talking to at the station that they should get the information of what happened from a PPO file?
So the PPO from the March 1st date that I shared, when I called the hotline, you have to fill out all this information.
Okay.
I printed that information and took it to the police station.
So is that what you're referring to as your written statement?
Yes.
Okay. So I'm understanding that we're clear. What you're saying is on some later date, you had requested PPO, correct?
Put the PPO information in on March 1st.
Okay, if I was, okay. Is it, okay. And then about approximately 3.5 weeks later, right? You went to the police and then we're talking to a police officer about what happened, correct?
Yes.
Okay. And he asked you to complete a written statement and you indicated that you would not, correct?
No.
Did you ever tell an officer Spavik? You only talked to one officer that day, correct?
Yes.
And did you ever tell that officer that you would not complete a written statement and to use the information from the PPO?
I said, can you use this information that I use for the PPO?
Now, you say that your husband, let me back a bit. So when you're having this conversation with your husband, and it's in this room, is he in the bed? Was he asleep when this started?
Not for sure.
Okay. So you come into the room, and then, but is he on the bed?
He's laying on the bed.
Okay. And at some point, you've already testified. You said what you said. When he does this, describe what he does. What does he do?
When he said what difference does it make and start laughing?
No, when you say that he physically attacked
I'm sorry, can you want me to, can you ask again? What are you
you.
asking?
I'm just asking you to describe to me, when you're talking to your husband, and at some point, does he get up?
Oh, yes.
Describe what happens.
So I said, he was laughing. He probably sat up when he was started laughing, and then
He probably sat up. Did he sit up?
he had to have sat up.
Did you see him sit up?
Yes.
And then what happened?
Then he said, he was laughing, and then I said, if you don't love me anymore, please leave. And then he launched towards me.
And there was nothing else said in between there except for that statement, right?
Yes,
And that caused him to stop laughing and just launch himself towards you and attack you, correct?
yes,
Okay. Now, when you went into the police station, you were asked by the officer to describe what you meant by the word choke. You remember being unable to verbally explain any details due to your emotional state. Do you remember being unable to verbally explain any details about what you meant by the word choke?
I know that I was scared to do what I did, which is go to the police station and to tell what happened to me to somebody else. Yeah, that happened. That did happen.
Okay, my question is, do you remember being unable to verbally explain the details?
Yes,
Okay. And then as a result of that, the officer then, with his hands, demonstrated for you, right? He did like this or something to that effect and made a demonstration with his hands as to what might have happened. Do you recall that?
no,
Okay. Would it be fair to say that on that day, March 25th, when you were in the police station, is it fair to say that you were unable to give the details? Is that fair?
yes,
Okay. Now, between February 29th and March 25th, Mr. Grissom wasn't living at the home, correct?
no,
But he had come to the home on several occasions, right?
on March 5th.
He came on several occasions to retrieve belongings and items that were his because he was sleeping in his car, correct?
I have no idea. He came on March 5th.
Is that the only day he came? Is that your testimony?
Yes, March 5th.
Okay. Did he come to the house to retrieve blankets, pillows, shoes, the various items that he needed to survive between the 29th and between February, so we're clear, February 29th and March 25th?
He has had my son come and take things out of the house.
That's not my question, man. My question is, did you see Mr. Grissom at your home between February 29th and March 25th? Did you see him? Did he arrive at the house and ask to enter?
I can't recall.
Okay. You can't remember?
I can't remember.
Do you remember letting Mr. Grissom in to retrieve a blanket or pillows or any of those items?
Objection asked and answered.
I'm trying to help refresh the recollection with the actual specific items. Maybe that will help the recollection of whether this man came to his house or not over the course of a almost month-long period.
Your objection is overruled. Ms. Grissom, you may answer the question.
Do you recall this man coming to the house to retrieve his
He
possessions?
came on March 5th.
Any other time other than that day?
I can't recall,
Okay.
sir.
On March 5th when he came, you let him in, correct?
Yes,
You didn't call the police and say, hey, this man that choked me is at my house, right?
Did.
Okay. you indicated that he had your son retrieve some things from him. As a result, you've actually you've actually required that your son call you and have a key code to enter your house, even though he has a key, because you don't want your son to be able to provide this in his family. Isn't that correct?
Objection, speculation, and relevance.
No, don't answer the question, Ms. Grissom. Your response to his objection.
It was relevant. She's the one that brought it up. You know what, I can move, I'll move past it. I will draw a question.
Okay, thank you,
I'll
Mr.
draw a question.
Bickert.
Mr. Grissom filed for divorce several weeks ago, did
I'm not for sure.
You're not for sure? Did you receive divorce papers?
No,
Is it your testimony here right now, as you sit here today, that you are not aware that Mr. Grissom has filed for divorce? Is that
I
your
did not
testimony?
sign for any divorce papers, sir.
Now, my question is, ma'am, are you, as you sit here today, aware of the fact that Mr. Grissom filed for divorce? Yes or no?
No,
Isn't it true, ma'am, that you brag to your friends that you put your hands on Mr. Grissom and that he won't do anything when you hit him?
no,
Have you ever said that to any of your friends?
no,
Okay. And have you ever indicated to your friends, look how small I am and how big he is, they'll believe me in court?
no.
Okay. During this incident, were you injured?
Yes,
Did you take pictures of the injuries?
no, I took Motrin.
Did you tell the police that you had been injured?
Did I tell the police I was injured?
Correct. Did you
I
tell the
thought that-
police that during this alleged attack that
Mhm.
you had been injured?
I thought when I said I was choked, when I wrote that meant injured.
You believe that ma'am, you have a master's degree, correct?
I do,
You believe that the word choked and the word injured are the same?
I do.
You never spoke to a Detective Long, have you?
A Detective Long. I did speak to a detective on the phone at the Van Buren Police Department.
I want to make sure I understood what you just said. You were at the Van Buren Police Department and then you had a conversation with someone on the phone
Yes,
while you were at the station?
yes.
Do you know, okay, and how, can you describe to me like how that came about? Like, did the officer call somebody else and ask you to talk to them, or how did that happen?
I went to the police department
Okay,
and talked to the lady to get the case number from my lawyer, and then
is this the date, is it the March 25th date that you made the report, or is it some other day?
another day.
Okay, so on some other day, you had come to the station. On some other day, you had come to the station, right? And then there was a call made that you spoke to somebody? I'm trying to understand what you're.
Yes,
Okay, and you believe that person on the phone might have been a police officer?
the Detective Long, I thought.
Detective Long, okay, you believe that was Detective Long on the phone that day?
Yes,
Okay, do you know what day that was, or approximately in relation to the day that you made the report?
no,
Okay, do you know whether it was like within a week or within a month?
don't know.
Okay. Okay. I'm almost done. Is it true that you were unable to recall when talking to the officer how long Mr. Grissom had put his hands on your neck? For how much time?
Remember?
And so, how did this end that night?
He packed his things and left.
and then he didn't come back, right?
He came back March 5th?
But I mean, he didn't come back to live, right?
No.
Um, When Ms. Christian came on the 5th, there were no problems between you and him, right?
Just said yes to whatever he said because I was scared.
Oh, you were scared on the 5th?
Yes,
When Mr. Christian came to your house, you were scared?
yes,
And you called the police as a result, correct?
did not,
You called a friend as a result, correct?
probably after.
After? Okay. What about your son? How old is your son?
How old is he?
Yes.
He's 22.
Did you call him?
I want to put him in the middle of this.
Okay. But when your son gave Mr. Grissom some of his belongings, as I asked about earlier, you did put him in the middle at that point, correct?
No,
Can your son use his key to get into your house where he lives?
yes.
Object to relevance to this line of question.
I have no further questions.
Any redirect, Mr. King?
Very briefly, Your Honor. I know
Yes, sir.
before it's execution for time. I just have a couple of questions. You had indicated that you took the Motrin as a result, is that right?
Yes,
Why?
because my throat was swollen.
Okay. You did not make this report right away. You would agree with that, right?
Yes,
Why did you delay in making the report?
because I never told anybody,
Why?
because I was embarrassed.
I don't have.
Anyone see you take the Motrin?
No,
Did you go to the hospital?
no,
Did you go to the doctor?
no,
And you didn't take any pictures either, correct?
no.
I have nothing further.
It,
I have no further questions, no further witnesses.
thank you. Ms. Grissom, thank you for your testimony. You may step down.
Do you want her to exit the courtroom, Your Honor?
Do you have any objection? Thank you.
I do.
I was going to ask Mr. Bicker if he has any witnesses.
If I could just have a moment.
Absolutely. Thank you. Thank you very much. I thought you talked to Fred about that.
You never had a chance to discuss the matter with Mr. King. I don't have any witnesses.
Okay. Mr. King, argument.
That other people will move for bind over on the offenses charged and reserve argument.
I would object without argument.
I don't think I've ever heard those words come out of your mouth.
Do you want argument, Judge?
Absolutely.
So, Your Honor, there has been elements, there's been evidence of all the elements of assault by strangulation. The complaining witness took the stand and testified to the date, the time, and the location, testified to a disagreement with the defendant after identifying. and testified that the defendant placed his hands around her neck, applying pressure, preventing her from breathing. That is the definition of strangulation. Further, she testified that she had a swollen neck thereafter and that she had to take Motrin as a result. This was a case of a delayed report, as is not uncommon in cases of domestic violence. I do understand that, there may be some credibility to be considered here on the part of the complainant. However, I would point the court to the applicable case law, that being People v. Anderson, 501 Mich. 175, in which the court addressed specifically the issue of credibility, stating that the standard is not, quote, do I believe this witness? But a magistrate may only decline to bind over if a witness's lack of credibility would preclude a person of ordinary caution from conscientiously entertaining a reasonable belief of the defendant's guilt. I believe if you look at the complaint, this is testimony, all the elements were testified to, and if you look at her credibility in light of the Anderson decision, there's been more than sufficient.
And I would just support that standard that counsel just read about credibility applied to this case. It would call for this court to dismiss this case. Then a reasonably prudent and ordinary person would seriously question the credibility in this case. He just read it. And I think that what we heard, we have absolutely no objective evidence at all in this case. And then what we have, and what we heard even in court, when I even said, well, hey, just describe it. Just tell us what happened. Right? At the end of the day, Judge, when the report is made 25 days later, and the officer asks, describe what happened, describe what you mean by choke. She testified under oath that she could not do so. So I would submit, Your Honor, that based on the standard that was just read by counsel, that and I apologize, I cannot hold the word, but that an ordinary, reasonably prudent person who had serious questions as to the credibility in this case, and I ask the court to consider this.
Anything else, Mr. King?
No, Judge.
Thank you. Court, having had the opportunity to hear the testimony of the sole witness in this case, that being Ms. Catherine Grissom, and appreciating, respecting the arguments made by the attorneys this afternoon, Mr. Bickert, the court thinks that there's room between somebody being not credible and something being incredible. And for that reason, the court will find that the people have met their burden for purposes of exam and will bind Mr. Grissom over as charged. The next appearance date will be an arraignment on the information on July 17th, 2024 at 9 a.m. at the Frank Murphy Hall of Justice. The previously entered bond with any of its conditions will continue. Was there anything else, Mr. King?
Your Honor, yes, there is an issue related to bond that the people do need to address. Your Honor, when the complaining witness entered the courthouse today, she was followed quite closely by the defendant, who then sat next to her and attempted to talk, although be it just a simple read. I have had conversations with the complainant. She indicates that she has been getting contacted by third persons on behalf of the defendant as well. She did, we could take further testimony on this, but the people do believe that this is of serious concern. The people would ask the court to reconsider the bond in this case, and at the very least, reprimand defendant for his actions, fully explain to him what no contact means, and potentially consider additional restrictions on his bond.
I'm choosing my words carefully.
No, speak freely.
I wasn't here. I don't know exactly what happened. But my first one, I find this. My understanding is that, yeah, that is in fact true. Mr. Grissom said hello. His current soon to be former. That as a result, Mr. Grissom was then chastised and reprimanded several times by the People's Victims Advocate. And I believe that's it, correct?
Yes.
I wasn't here, so I didn't address it. I then was asked by Mr. King whether we were going to hold this exam over. I said, well, we're going to hold it. Mr. King responded by, well, I'm going to move to revoke your client's file. And then I said, well, Mr. King, that sounds eerily like a threat and to have a chilling effect on my client's right to have his exam. And he said, well, I'm going to move for that either way. That's not the case. I said, okay, fine. In the day, Your Honor, my client, this is an allegation from February 29th. My client had no contact other than what was testified to apparently on March 5th with the complainant from that date until March 25th when she reported the crime. He's also not alleged to have had any contact after that. Here today, he's present. He has several contacts from various miscellaneous numbers that are in response to dates that he filed papers, etc., in relation to his divorce. In the day, Your Honor, Mr. Grissom very much understands that he's not supposed to have any contact. He does not desire to have any contact. We have no problem with the court reminding him of that, but we certainly would object to any change in bond. That he's not doing anything wrong. Quite frankly, this is just more of the same of why we're here. Now we're asking, well.
Anything else, Mr. King?
Again, Your Honor, I mean, we could take testimony on this issue. I think court staff saw it as well. But to say that he didn't do anything wrong when there's an order of no contact and he literally follows the complainant into the courthouse closely and sits next to her and tries to talk to her, I mean, that is a blatant bond violation, Judge. You saw the mannerisms and behavior of this complainant. She has expressed fear of this defendant, and that is part of the reason why these no contact orders exist.
Uncross your arms. I have been here since 8:10 this morning. I left for 45 minutes to go to lunch. If there had been something that was objectionable, I would expect someone to speak to the officer assigned to this courtroom, who is Officer Brooks, or Officer Rapp, or Officer Garcia, or Officer Ramsey, or anyone else in this building to relay concerns so the court could move and address it. That being said, so we're on the same page, Mr. Grissom, because I'm not the one that arranged you, someone else did. My arraignment conditions are very specific and precise. I don't know what happened before 3:19 today, but I will say to you right now, you are to have no contact with Catherine Grissom. No contact means no contact. No direct contact, no contact with social media, no contact with third persons. This court is losing jurisdiction of this case today. It is going to circuit court, but the no contact order remains in place. Should Ms. Grissom make reports to the Department of Public Safety that you've made efforts to be in contact or communication with her, I'm sure the circuit court could view that as a violation of the terms of the bond. The bond could be revoked and you could spend the rest of these proceedings in custody. I'm not asking you to respond to what is alleged to have happened today, but do you understand what I mean by in custody?
Yes.
Wayne County Jail.
Yes.
No contact means no contact. Your personal bond remains in place. Marianne will get the paperwork together. Anything else, Mr. King?
No, Judge.
Anything else, Mr. Bickert? Uh-huh.
Your Honor, one, Mr. Grissom, in conjunction with the PPO filing that occurred by the complainant, I'm not sure on what date, they have had a court proceeding. The judge in that case, at an addendum to that PPO, indicated that Mr. Grissom could, and I actually don't last year, that he can go to the house to retrieve his belongings. Now, they have a scheduled date to do that. What is that date?
July.
They have a scheduled date to do that. So he's just asking to be allowed to do that.
Are you aware of that date?
The victim did mention that there was some PPO talk and discussions about a date in July to exchange belongings. However, Your Honor, there's two orders. There's a PPO, but there's also this court's no contact order. I would ask that if that exchange were to take place, it should be done by a civil standby and police should be present.
I believe that's how it's set up right now. It's already how it's set up.
If there is already a date from a higher court, if there is already an order from a higher court that sets a date for Mr. Grissom to exchange, go to the property, go to the residence to get property, the court, this court can't do anything to undo that order. And as Mr. King indicated, that should be effectuated with civil standby, which that's something for the Department of Public Safety. If there is a court order already, that would be the only exception to the do not contact. And it's, if they've already said, Mr. Bicker, there's no reason to have contact. There's a reason to appear on that, whatever the date is that's already been ordered by the judge who entered the order in the PPO. Not the cleanest record, but I think it got done what it needs to get done.
So that date will happen, but police need to be there. Is that the summary?
No,
Correct.
What the court said was that there was a higher court order that put that in place.
I thought you said he said civil standby. Do you have any objection to a civil
What
standby?
I'm saying is, no, I don't really have any objection. I don't
Oh.
have an objection to it, but the third circuit court's orders, as the court stated, it stands how it stands. I don't know what it says exactly in detail.
But you know how to get in contact with Mr. Grissom. And Mr. Grissom knows how to have conversation with you so that there's not a bond violation. So that grown people can be grown people and work out the day and time.
We agree with that.
And the Department of Public Safety, I'm sure, would rather have a civil standby than something else.
We have no objection.
That being said, anything else?
No, Judge.
Anything else, Mr. Bicker?
Nope.
That concludes this hearing. That concludes this court's docket, and we stand in